Hello, everyone. Good evening, and welcome back to LiveLaw Academy. I hope all of you are doing great. So, today's topic of discussion is related to high courts, various high courts in India. I have tried to structure the lecture in a way as to where you will, you'll understand the topic in context of the previously asked questions. So let's start. Let's begin with the discussion. We also have done a video on Supreme Court of India, which is available on LiveLaw Academy, and you can accordingly watch it from there as well. So now, when we talk about high courts, we have various high courts in India, right? And we have unified judicial system wherein we see that we have the Supreme Court as the apex body, and beneath it we see that we have different high courts, which is the appellate body within the state, and underneath there we have different subordinate courts, right? And accordingly your questions are asked in this manner. So to begin with, we have to see that how did the high courts come into existence. So there was a point in 1862 wherein we established the first set of high courts in the presidency towns, that is Bombay, Madras and Calcutta. Okay, so your journey starts from there, wherein we see that the first leg of establishment of high courts happened there. Then the fourth high court was established in 1866 in Allahabad, and that is why you must have seen or you must have come across the term that Allahabad High Court is one of the oldest high court. That is the reason for the same. Okay, and then from that we move to the third, the third leg, wherein there were establishment of different high court in various provinces. So this has been the journey. And now with 1950, when we introduced the Indian Constitution, in 1950, when we introduced the Indian Constitution, these high courts in the provinces were transferred or were transformed into high courts of the state. And that is how we have the present structure of high court. So this has come up, or this is now there. The establishment, the organization, the powers of the high court is regulated and is to be seen or is to be dealt by what is mentioned in the Indian Constitution. So Indian Constitution, from Article 214 to Article 231. Now you have to compare and remember, okay? For example, Supreme Court is covered in Part 5 from Article 124 to 147. So likewise, remember at least the structure of it. And under that also there are certain provisions which are very important for your exam perspective, okay? Both pre as well as mains exam. So this is where you see that the High Court, or who all will be there in the High Court, what will be the strength, what is going to be the structure, all of this is mentioned in the Constitution. In addition to this, we have the memorandum of procedure, which tells us as to how the appointment is to be done. We have the second judge's case, which gives us more clarity as to how the appointment of the High Court judges will be done. Okay, so all these three things come together, and there are various other statutes like the procedural laws, that is CPC or CRPC, or when we talk about Letters Patent Act. These are different additional laws which also adds on as to what is going to be the authority, jurisdiction, and the power of the high courts. Okay, so I hope you will remember these important points. Now moving ahead, as I told you, this is the first slide that I've covered already. We established these high courts, and then later in the Allahabad High Court, and there are now different high courts to all the corresponding states. We also have various high courts which share their boundaries, or which share their the jurisdiction is extended to the union territories or other states as well. So, okay, so it's not just one high court for each state, rather there are states and union territories which share boundaries with each other, and this was allowed by the 7th Amendment Act of 1956. Okay, so therefore the parliament was given the power, or was extended the power, that they can have they can have a common high court also, which will be established between the union territories or between the states. Okay, now mostly the jurisdiction, when we say the territorial jurisdiction of a high court, is coterminous with the territory. So whatever is the territory, okay, if I say this is the territory of Delhi, the jurisdiction of the Delhi High Court will accordingly be between those, the physical territorial jurisdiction of the state. And that is how we try to find the jurisdiction of a particular high court. All right. Now, what is the composition? So, if you remember, if you have attended my lecture on the Supreme Court and the strength as to how it works, you must have seen that, we have given the strength, we have added the strength, we have provided the power that the parliament can enhance strength also. Likewise, here in High Court. And if you compare and try to remember, it will always be easier for you. Okay. So, High Court will consist of Chief Justice and such other judges. So, therefore, the limit has not been mentioned or has not been circumscribed by the Indian Constitution, and rather this is something which we decide, right? So you, if you're preparing for, let's say, Delhi Judiciary, if you're preparing for UP Judiciary, accordingly, after today's class, go to the website and try to see the strength of those of your High Court. Try to see what is the sanction strength, try to see what is the present strength, and accordingly be aware about the structure. Okay. Now, besides that, the president has the power to appoint the chief justice and other judges. He can also appoint additional judges and an acting judge. Okay, additional judges, as the name sounds, is in addition to the existing set of judges. So, whenever there is a lot of work, we realize that for clearing of the work, we have additional judges also that can be appointed. And very important for you to remember that it should not be, their tenure should not be exceeding 2 years. So this is only and only that, wherein we see that yes, there is the high courts are swamped with work and there is arrear of work and it has to be cleared within time. In that situation, the president can appoint the additional judge as well. Okay, we will come to the appointment, that how the president is going to come up with the name. So we'll try to understand that as well. Then we have acting judges. So in the absence of a sitting judge, there can be an acting judge who can be appointed and who will be temporarily, in the course of the absence of the actual judge, can actually substitute and do the work. So that is why his name is called as acting judge. The age of retirement is 62 years. So Supreme Court, we have 65 years. High Court, we have 62 years. And you should also be knowing that, there are certain impediments or there are certain restrictions for a retired judge as to what they are allowed to do after their retirement. Okay, so that is one of the aspects, that why we have put a time limit, why we say that okay, after 62 you get retired as a judge, and therefore there are different other revenues, but there are also certain restrictions. Okay. All right, I'll come to the part of the different jurisdiction that they have. Let's just go to the appointment in the chronology. So we were understanding the appointment is to be done by the president. But how does the president really do the appointment? So it is not that he is coming up with the name. There is a chronology of different procedures that take place, right? And that is what I informed you, that this law is to be read with other things as well. So the memorandum of procedure tells us that there will be initiation of the proposal. Whichever high court has a vacancy, whichever high court the chief justice realizes that we have to do the appointment, the chief justice of the concerned high court will initiate the proposal for filling of the vacancy. Okay, so keeping in mind that there is a requirement, the chief justice will be giving the name, and this name has to be finalized not only by the chief justice, but he has to rather consult with two senior most judges of that high court. Okay, so this is a collegium at the first stage, and there are two collegiums here. One collegium at the High Court level, the other collegium at the Supreme Court level. So here we have the Chief Justice plus two senior most judges who are going to do what? Who are going to be the part of the collegium at the state level. Okay, and this has to be the name that we are going to give, the qualification that is required is that the person whose name is being suggested has to be a citizen of India. He should at least have 10 years of experience of holding a judicial office, or at least 10 years of being an advocate in the high court, okay, or two or more high court. So that is the other way, that first and foremost you have to be in this category, you have to have these qualifications, and then beyond this your name will be picked because there's so many people in the same pool, so your name should be picked based on merit, seniority, integrity, and suitability. So this is to bring more transparency in the appointment procedure. We have mentioned it to be followed in this manner. Okay, then the after the name has been finalized by the High Court Collegium, now the name has to go to the governor, and from there it goes to the Union Ministry. Okay, so the Law Ministry will be given the name, and this is passing, or this is going through the channel of where the governor advises. Okay, so this is the second stage by which we see that the name has been now submitted to the Law Ministry. The Law Ministry will do the background check. The Law Ministry will see whether, whether you are a person of integrity and all these other factors, and then transfer your name to the Chief Justice of India. So that is why when you are trying to remember, it may look confusing, but at the same time, if you put thought to it, you will realize that we start from the state judiciary, we go to the governor, we go to then we go to the ministry, and then we go to the Chief Justice of India, and from there the name goes to the president. So there is involvement of executive, legislature, and judiciary in the appointment here, right? So that does bring balance also, but at the same time there are cons as well. So from here, now when it reaches to the Chief Justice of India, we already have clarity from the second judges and the third judge's case as to what is the power of the CGI. When it is written that the CGI has to give the name, or the president has to, on consultation with the Chief Justice, recommend or appoint a person. Now comes the factor of the power to be exercised. Okay, so the CGI is not, again, not alone. The CGI has to consult people, and consultation is to be seen in context of concurrence. Okay, so all three people have to come together and decide whether yes, the name should be forwarded to the president or not. So the second collegium is here, where the CGI, Chief Justice of India, now is in consultation with the two more senior judges of the Supreme Court, giving out the name. Okay, so this happens at the fourth stage, wherein the name has been finalized by the apex court as well. And now this goes to the president, and the president accordingly appoints the respective person whose name has been suggested by warrant under his hand and seal. Okay, so this is the chronology for you to remember as to how does it work. Now there are certain important factors to understand this better. First is, what is consultation? So consultation we have understood already, that is that there has to be appointment, there has to be consultation with these two senior most judges. That the other point is, consultation is equivalent to the term that is concurrence. Okay. Yes, okay. So we have understood that what is going to be the procedure. I've already told you this is not entirely coming, or this is not entirely based on the other Indian constitution, rather a mixture of a lot of things. Okay. Now the next thing is that we have jurisdiction of the High Court. These are hot topics, and these are topics which are asked time and again. Now you see that, with the entire a lot of discussion with regards to how the judiciary works. Now we see that we have to, we have to prepare ourselves for these topics very, very particularly. So Supreme Court as well as High Court becomes very pertinent for your exam preparation. Okay, so the jurisdiction of the High Court is again going to be very similar, but again at the same time somewhat different also as compared to the Supreme Court. The High Court will have original jurisdiction, appellate jurisdiction, supervisory jurisdiction, control over subordinate courts. That can be administrative jurisdiction also. It will be a court of record, and accordingly has to maintain the record. They will have the power of judicial review as well, which is the idea, or which is the part of the basic structure, and which cannot be vitiated or taken away from these courts, these constitutional courts. Okay, and then of course we have the writ jurisdiction. So these are different type of jurisdiction. We will get to understand one by one. We will try to understand these jurisdiction, and then I will show you two judgments which are relevant to the context of the power that the High Court possesses. Okay, so when I was telling you that we have CRPC and CPC, remember that, or BNS, BNSS, sorry. we realize and we acknowledge the fact that these give you the inherent power. You being the high court, you've been granted certain inherent power, okay? And these inherent power accordingly has to be seen in that context. So whether this is wider, whether this is narrower in nature, this is something that we are going to understand from the judgment. Okay, so what are the original jurisdiction? What are the grounds of directly going to the high court? So these are the different grounds that are so mentioned here. Okay, a party can directly reach to the high court. The otherwise you're supposed to go through the channel or go through the mode of the from the subordinate courts you reach to the high court. But in these cases where, let's say, you have a revenue matter wherein you see this, it is related to the election of the members, in that situation definitely you can directly reach to the high court, invoking the original jurisdiction of the high court. So that is one important aspect. And revenue matters is something very important that you should remember when you're writing your answer, because this was later added. Okay, initially it was not there within the jurisdiction of the high court, but later we added the same. All right. Then we also see that there are certain high courts which have original jurisdiction because of the commercial value of the suit. For example, the Delhi High Court, if the value of the suit is more than 2 crores of rupees, you can directly reach to the High Court as well. Okay. Invoking their original jurisdiction. So that is why it is relevant for you to, if you are preparing for judiciary, you are part of any of the state judiciary, you're aspiring for it, you must definitely know whether this is applicable there or not. Okay, or if it is applicable, what is the amount or what is the value of allowing the same to the parties. Okay, so this is another important relevant factor for you to remember. All right. Now, then we come to the writ jurisdiction, wherein we very clearly see when we read it from Article 226, you will see it says that the High Court can issue writs for mandamus, quo warranto, all these 5 writs which are part of the Supreme Court already. Okay, but at the same time, it uses the term and for any other purpose. So this brings a lot of confusion as well as expansion of the rights of the High Court. That how the High Court's scope of High Court or the authority of the High Court is much more wider in nature as compared to any other subordinate court. Okay, so this is important for you to remember, or the Supreme Court. Sorry. Yes, when we try to compare this with the Supreme Court, we realize that the High Court will have a much more wider power, or the authority to issue writ is much more wider because they can issue the writ for any other ordinary legal right as well. Okay, so not only for fundamental right, which is part of the High Court, but any other ordinary right as well. Okay, then the next point is that the writ jurisdiction is not exclusive. So this does not mean that you cannot reach to the Supreme Court. Okay, and therefore these are not exclusive, rather concurrent in nature. Of course, it's always preferable. The court would want you to first seek the remedy from the High Court and then come to the Supreme Court. But accordingly, you at the same time you have both the remedies available, depending on the nature of the wrong that has taken place. You can accordingly invoke the same. Okay, and therefore we understand that we conclude that the remedy of the High Court is much more wider than the Supreme Court. We have a very important and relevant case here, the Chandrakumar case, wherein the court has clearly mentioned that the writ jurisdiction of the High Court is part of a basic structure. It cannot be curtailed or it cannot be taken away. Okay, so in no way you can exclude the writ jurisdiction of the court, and it has to be accordingly be protected, keeping in mind the idea of introducing the concept of writ jurisdiction. Okay, then definitely the High Court has appellate jurisdiction from civil matters. The appeal lies there. From criminal matter, the appeal lies there, as well as from tribunals also. Certain tribunals, the appeal goes to the High Court, or otherwise mostly it goes to the Supreme Court. Okay, so remember the third type of jurisdiction is the appellate jurisdiction, where the High Court now has to primarily start with the appeal. Okay, so this is the first stage of appeal. Then for civil matters, it is restrictive in nature, very specifically mentioned that when do we allow first appeal, when do we allow second appeal, and whether we have intra-court appeals or not. Okay, so the first appeal will happen only and only, first and foremost, when you exceed the stipulated limit. Okay, that is the first thing. Secondly, when the party the party can also reach out to the high court for the interpretation of question of fact and question of law. So this is the first appeal, which is very regular in nature. For the second appeal, now you are expected that it is based on question of law and not just question of fact, and accordingly you bring the appeal to the high court. Okay, then the third one is the intra-court appeal, which is very, very important and very exciting also, wherein we see that from a single bench, you can go to a division bench. So single bench will have one judge, division bench will have two judges, and you can do this only and only to ensure that you do not burden the Supreme Court, and at the same time you give an opportunity to the court to review their decision. Okay, so that is why these are called as intra-court appeals, or also called as letters patent appeal. Okay, so this is the name. LPA or letters patent appeal comes from the fact that this is something which is to be shared between the parties. Okay, so this is another important point which I would like you to remember. Yes. Next up, we see that we have this case, this landmark case, wherein the court has very clearly and specifically clarified that the appeal can lie from a tribunal. It will go to the High Court, division bench of the High Court, and at the same time, it is also clarified that the writ jurisdiction can be invoked for the same. Okay, so the tribunals are subject to writ jurisdiction. Whatever the role or authority is given to the tribunal is absolutely separate and different from the authority of the court. Okay, so this is the landmark case which you're expected to remember. Then from the criminal matters, the appeal lies. Yes, it is subject to the punishment that is to be put, right? So an appeal will lie from the judgment of a sessions court and from the additional sessions court, wherein the sentence is one which is of more than 7 years. Okay, so depending on the nature of the punishment. Then also, if let's say you have given death sentence, in that situation, even if the appeal has not been filed, you have to get a confirmation from the High Court, right? So accordingly, for death sentence also, does not matter whether the parties are referring or not, the confirmation has to be done before it is so executed. Okay, and then we also see that if there are, when the judgment or when the sentence has been passed by the additional session judges, it can again be it can be an authority of appeal to the High Court. Then no appeal from a sessions court is possible, and specific provision will be allowed specifically when it is so mentioned in the law. So you have to remember that it has to be done. Appeal is a statutory right, correct? And therefore it has to be regulated and it has to be seen subject to what is so mentioned in the law. All right. Moving further, we also have the power of special leave to appeal. So you can always, when the magistrate has granted acquittal to an accused, wherein the case was instituted upon a complaint, wherein the High Court on such application realizes that this has to be assessed by us in the appeal, and accordingly the High Court can pass or give the special leave for dealing off with the same. Okay, then we also see that the High Court can do that in exercising their jurisdiction of having inherent power under section 482, which allows them again to secure the ends of justice. And therefore, these are different ways by which you reach to the High Court in the appellate jurisdiction of the High Court. Okay. Then the last discussion will be from today's class related to Article 227. We have two provisions, Article 226 and 227, which deals and which talks about the authority of the High Court. We have tried to understand that the scope of 226 is with regards to writ jurisdiction, for which tribunals can also be part of the same. At the same time, we also have Article 227, which tells us about the authority of superintendence or the power of superintendence to be exercised by the High Court. Okay, so this is the supervisory power of the High Court, wherein we have specifically mentioned that they have these grounds on which the supervision can be done. So they can call for returns from such courts. They can make and issue general rules, prescribe forms relating to practice and proceeding of such court. They can prescribe form in which book entries, account, all other things have to be kept. And they can also at the same time take care of the tribunals. But the only exception is that they will not be the court of superintendence for the tribunal related to armed forces. So, except AFT, this is also asked a lot of time in your preliminary examination. So, remember that except AFT, we have all these grounds wherein we see that the High Court will have the power of superintendence or of supervision, and they can accordingly exercise this authority. Okay. Now I'll to show you two cases wherein the jurisdiction and the power of the High Court has been discussed very specifically. One is the Sadhana Lode versus National Insurance Company case. Let's go through this. First and foremost, it talks about the right of appeal being a statutory right. It cannot be enlarged or it cannot be restricted by the law. Okay, so by the parties, it has to be read in consonance of what is so mentioned in the law. And that is why the parties here, the court here, before discussing on the scope of 226 and 227, has clarified the same, right? Then when we talk about whether, if let's say in a situation we are discussing of as to how and what is the scope of the power or the authority given to the courts under Article 227. Very specifically, it has to be seen that the appeal can be filed provided that it is not specifically barred. Okay, so it has to be first either mentioned in the law. Second, if it is barred specifically, you can't be invoking the supervisory power or the writ jurisdiction and then say that okay, this can be applicable. Okay, so where the state legislature has barred a remedy for filing a revision petition, the High Court under Section 115 of CPC, that is the again inherent power, cannot, in no situation they cannot do this. No petition under 226 would lie for the reason of the mere wrong decision without anything more is to attract the jurisdiction of the Article 226. So this is not this is not something that is the judicial review power. Rather, it has to be seen in consonance of the idea of Article 227, which I just showed you, right? All right. Now, the next thing that we have to understand is that how does as you see, they can tell the parties as to how the records have to be maintained. So all of this under 227, the authority or the power is administrative plus judicial in nature. And that is why if you get ever a question as to whether 227 is wider in nature as compared to 226, your answer will be yes. Why? Because 226 is related to writ jurisdiction, and it also allows that for legal rights also, all other ordinary legal rights also, writ can be issued, right? But at the same time, 227 is much more wider in nature, when in it very specifically highlights and tells us that the parties will have the court will have, the High Court will have the power of superintendence, and this is not subject to procedure or the technicalities or the requirement that it has to be related to fundamental right. All of that is not a mandate to be proven here under Article 227, and that is why it becomes the jurisdiction of this particular article becomes much more wider in nature. Okay, then we also have the case of Varyam Singh versus Amarnath, wherein the court has specifically so spoken, and they have discussed that how the High Court in the present times have evolved. We also had this in past, wherein they had these revisional jurisdiction and other jurisdiction, and this has now been incorporated in the Indian Constitution as well. So these powers, when we are trying to read and understand the scope of it, can be read in the context of what was there in the past as well. Okay, yeah. So with this, I think this will help you in understanding the concept, and this will help you in submitting answers and in writing decent answers for your exam preparation. I'll be coming up with part 2 related to the High Court, wherein I'll be solving questions with you. So do watch for the space for other updates, and I'll see you again with another relevant topic to your examination, and all the best for your judiciary exam preparation. Thank you so much.